She is extremely smart about the law. She knows a lot of what your concerns are. I'm going to leave it at that. I did kind of a free intro before the break, so I'll leave it at that. Hilary Bricken.
Thanks, Brad. Okay. Hi, everybody. Good afternoon. 3 o'clock hour on Friday. I hope everyone is caffeinated and energized. And I have to ask, I do this every time I speak publicly, who are my attorneys in the room, just so I know who knows what? Okay.
Hey, Hilary. There's a microphone right over here. And sure, you're not using any PowerPoint? Sure.
No, no PowerPoint, no slides. Is that better? That's fine. Okay, so I've got my, all right, so let me gauge also the knowledge here about the regulatory space and the legal situation, because it's not straightforward in California. It's not been straightforward on the West Coast since 1996, basically from Alaska down to the California border. Who has a really good idea about what Prop 215 is and SB 420? The existing laws, right? A couple people, okay. Who knows what the Medical Cannabis Regulation and Safety Act is? Good, it doesn't matter, it's been repealed, but good for you. All right, and who knows what the Medicinal and Adult Use Cannabis Regulation and Safety Act is, AKA SB 94? All right, you got some all-stars in the room. Okay, so I call that particular law Mau Cursa. That's how I say it, because I just cannot fit all those words in my mouth at once. This is the new era of cannabis regulation and government oversight that's going to commence in 2018, officially in January, but for some of you, temporary licensure is going to be available probably as early as October. Okay, now let's start from the very beginning, just because we do have some one-on-one folks in here, I'm sure, that want to know the history, and I do have 45 minutes. Basically, in 1996, California was the first state to develop really kind of a permissible medical marijuana program. It was not legalized. That is really important to note. Qualified patients still to date are only entitled to what's called an affirmative defense. Who knows what an affirmative defense is? That's good. I'm not a criminal lawyer, so I had to look it up. But basically, it's a lawful excuse to break the law, and it can only be essentially triggered, used at certain points in your criminal prosecution, namely at trial, okay? So that's all that qualified patients get under Prop 215. Now, I'm not gonna go through all of the possession thresholds or the plants that you can have, but basically what happened over a series of years was that this became commercialized. And SB 420 is really the bill that kind of gives us the collective model that was built on the back of Prop 215. Who knows what a collective is? Who knows that that's not actually a real legal term? Okay, very good. In 2008, Jerry Brown's office, when he was Attorney General, came out with a guideline memo to tell everybody, we have this very screwed up situation in California where we have a ton of qualified patients that are basically interacting with each other in a commercial way, but no government oversight, no one's paying their taxes. How do we deal with this? And they looked at Prop 215, which literally says that qualified patients can come together to collectively and cooperatively cultivate and basically trade up medicine together. So Brown's office looked at cooperative and collective and basically said, if you want to do this on a commercial scale, you need to form a nonprofit. That is how we read this. And it's got to be either a nonprofit cooperative or a nonprofit mutual benefit corporation. Now, most of you that have been in the industry, you know, the second of those two entities is the common entity that people use, frankly, in my personal opinion. It's because there's less filings and reporting with the Secretary of State. It's just easier. But Brown's office gave that option. Now, that memo is just a memo. It was the Attorney General's interpretation, basically, of Prop 215. And that actually has held a lot of water over the years with law enforcement and would-be entrepreneurs. That memo is taken at face value as the law, but depending on the lawyer that you see, from San Francisco down to San Diego, they all have a different interpretation of the limitations and liberties you can take under Prop 215. So this is a very long way of saying it is a complete and total mess. Now, what happened in 2012? Anybody remember? Colorado and Washington legalized adult use cannabis, basically for adults 21 and up. You can possess up to an ounce or less, and they created the nation's first regulatory regime that basically from seed to sale regulated cultivators, processors, and retailers. First time really ever. Colorado went a little quicker than Washington did because they had regulation in 2010. Washington, much like California, had nothing, so they had to build it from the ground up. Now, on August 29th, 2013, we basically get the first enforcement memoranda from the Department of Justice about how the DOJ is going to handle this particular situation, now that we have 2 states which by ballot initiative, which is direct democracy in action, that is literally the people changing the law, have decided to opt out of federal prohibition for regulation and taxation. DOJ comes out with a memo. It was authored by then Deputy U.S. Attorney James M. Cole, and what it had to say was, these are our 8 enforcement priorities. And number 1, we're not going to sue Washington and Colorado in federal court to overturn their cannabis laws. We don't care about that. We don't have the time. We don't have the money. What we are going to do, though, essentially, is relinquish control to local governments and local agencies to enforce our 8 priorities. And if a state does not have robust enough regulation, we are going to come in with the full power of the Constitution behind us. Small footnote, this doesn't change the law. We hate marijuana. You guys are all on notice, basically, is what it said. Now, this was not the first time that the DOJ had opined about how to enforce marijuana laws. And be mindful, if you are a lawyer in this industry, if you are an entrepreneur in this industry, if you are a consumer, this is not the law. It can be changed at any point in time. Jeff Sessions has threatened to change it probably innumerable times at this point. He has not. And it is not something that's going to be used as your defense. However, every state has now built its regulatory regime on the back of that particular memo. So it is relevant, but it can change. So what inevitably happened in California, and I'm sure Assemblymember Joe Sawyer talked about this morning, California could not keep going down the rabbit hole of Prop 215. It was putting qualified patients and collectives in grave danger with the federal government, believe it or not. Depending on your city, if the locals really didn't like you, you may see a DEA raid or even worse, federal indictment and prosecution. It was happening all over California. Who knows how many US attorneys California has? Doesn't anybody go to trivia, like during the week? 4 people, it's like the most out of any state in the United States, and they're all super aggressive and they really loathe marijuana, so it's important to know who they are and what their agenda is, so it is 4. That is by far the most, again, in the United States, probably next to Illinois and Florida. So what happened, essentially, was that the legislature finally got its act together and basically decided, as the result of the legalization of marijuana in 2012 by Colorado and Washington, and as the result of the Cole memo from 2013, California needed to get regulated, or it was going to continue to have issues with the federal government, which produced what? The Medical Cannabis Regulation and Safety Act that passed in October of 2015. This was the first time in 20 years since the passage of Prop 215 that the legislature had gotten active in the regulation from seed to sale with 17 different kinds of licenses for medical marijuana operators, okay? Now, what also happened in 2016 was that the state voted, right, to legalize under the Adult Use of Marijuana Act. Now, that one was way more liberal. They shared some similarities. The license types were the same, but admittedly, the AUMA was way more progressive, way more business friendly, way more easy access than the MCRSA. Now, of course, that could not stand, and what's happened in other states, and I think thankfully California has learned from this, recreational cannabis inevitably swallows up medical cannabis. The two tend to compete with each other, especially if chronic pain is on the list for medical cannabis, which California has had from the beginning. It's very easy access. A lot of people don't report their taxes. They're not adhering basically to best practices. It can be very fly by night, right? So essentially what happened was that the state decided to combine the 2 laws to head that off at the pass in the future. It was also to make uniform the entire industry. So now we have MALCRSA that passed this summer. Again, that was the governor's trailer budget bill, SB 94, and it finally combines the MCRSA with the AUMA under one regulatory regime. And the leading agency is who? The Bureau of Cannabis Control. But there are 2 more, the Department of Health and the Department of Food and Ag, okay? Now we can actually talk about what's in MALCRSA, but I'd like to know, who has read SB 94? At least once. Okay, a little bit. All right, that's good. It's not an exciting piece of legislation. It really just kind of highlights the differences between the MCRSA and the AUMA, and really what we're going to see going forward actually is going to be in the regulations, which will come out probably sometime in September. But the MCRSA has been repealed by the passage of MALCRSA, okay? All of the regulations that came out under the MCRSA at the end of April, it was 200+ pages, those are going to be withdrawn this month. But I can guarantee you, if you did read those, and I hope some people in this room did, we are going to see some iteration of those rules come back. And even though Mount Cursa, I'm going to go through some of the highlights, is much more business friendly, these agencies may not be. And it hinges on everything from how you can transport the product, delivery is on lockdown, how retailers are going to have to basically vet consumers when they come in, to prohibited products list, to your pesticides, your power sources, your resources. You're never going to sleep at night again, is basically what I'm saying, once regulation actually drops. And that's going to be a rude awakening for some folks that have been operating under Prop 215. Frankly, a lot of people will never come into the regulated system. They will go to ground, and they will continue to export illegally across state lines. What you will see, and it may shock you, is that there will be a lot of self-policing between entrepreneurs. And competitors actually will report on each other. They will tattle to each other, to the state. They will make sure that if they find black market actors, that they're snuffed out. How do I know this? I've seen this in Oregon and Washington, and before California, I was practicing in Seattle and Washington for 7 years, helping entrepreneurs in a very similar collective model basically broach the transition into regulation. It is not pretty. And I was just telling Brad, the majority of people will fail. And they will fail because regulation means what? Money. It costs a lot to have a regulated cannabis business, and it costs even more to abide by the federal enforcement priorities, to pay your taxes under 280E, and don't even try to get institutional investment. A lot of what's been reported to me is very misleading. A lot of the investors are actually looking at the cannabis adjacent industries like lights, tech, real estate. They're not actually putting money into operators because they are way too volatile, okay? Now the good news is that probably 2 to 5 years from now, the market will stabilize. You'll be able to value your businesses accordingly. Some people will survive, and there'll be a big consolidation. There'll be lots of M&A work, basically selling businesses, acquiring businesses, and some people will be legacy operators, but most people will fail because regulation is intense and it's expensive. So does anybody have any questions based on the downer I just became? Yes?
I'm a real estate owner, say, and I have a 40,000 square foot industrial building, and a grower rents my space for 10 years. Can I be taken down by the feds?
I love this question. So I'm a landlord, I have a juicy piece of property, let's say it's in one of these municipalities that's actually regulating it. Do I have criminal liability? Can the feds take my property? The answer to the first question is yes, there is criminal liability. And again, not a criminal lawyer, but enough to know the landlord in particular could be found to be aiding and abetting and conspiring to violate the Federal Controlled Substances Act because you are enabling the illegal business to continue operation via your lease. Now, typically they do not pursue the landlord. There's lower hanging fruit, the actual operator. But what they do like to do is asset forfeiture. And for the first time in 2008, commonly known fact, they hit $1 billion in forfeited assets, meaning cash, cars, homes, art, you name it, including real property, that was derived from or used in a federal crime. Now, most of those forfeitures are from drug crimes because those are easy pickings. And what happens in forfeiture is that it can be civil, criminal, or administrative. When it's criminal, there are criminal charges brought against somebody associated with the property, typically the owner. Civil, there are no charges. There's a civil suit that typically follows. Mostly, it's administrative, okay, which is a hurried up procedure where you get a forfeiture notice on the door, and you have to show up to court as a third-party claimant. The defendant is actually the property, okay? Now, you have one defense and one defense only. It's called the innocent owner defense, which means, and this is very specific to real property, you didn't know or you had no reason to know that the criminal activity was taking place on the premises. So it's an actual knowledge standard and a constructive knowledge standard. Now in California, and in any state with regulation, this is not going to help you. The reason being, when the state asks for your application as a licensee, they will mandate that you provide a lease agreement or a deed to show that you have a right to use the real property and the landlord knows it for the license type for which you are applying. So your innocent owner defense is gone. And the key to mitigating this particular relationship, which I examine a lot, as always, is through the lease agreement. You have to address what happens in the event of forfeiture. Now, who knows who Harborside Health Center is? Yeah, a lot of hands go up on that one. They are the notorious case of how not to do it when it comes to a lease agreement, because essentially, and I think they would probably admit to this, they held their landlord hostage for a good 4 to 5 years over her properties. The federal government one day, and it was Melinda Haig, who is the US prosecutor in the Northern District, decided they're just too big. Didn't pursue any criminal charges, just went for forfeiture of 2 properties in San Jose and Oakland. Immediately, the landlord moved for unlawful detainer. After trying to negotiate Harborside out of the space, they said, no, we're not leaving. Basically, we want to fight the forfeiture. So, landlord goes into state court, unlawful detainer, which is an eviction proceeding, tells the court they're violating the Controlled Substances Act. They are drug dealers in my space. And the judge says, well, let me see the lease. And the lease specifically says that they can undertake basically the retail sale of cannabis pursuant to Prop 215, and that the lease will be upheld pursuant only to California state law. Made no mention about federal law. So the judge said, look, factually, they haven't done anything wrong. They're not in breach of the lease. In fact, they're actually good tenants. They're current on rent. They're not in default. And no unlawful detainer, which was pretty surprising based on the way that lease was drafted. So then what happened was that the landowner went into federal court in the forfeiture proceeding and said, federal judge, you have to get them out. Okay, they're violating federal law, they're drug dealers in my space, I've tried to evict them, it's not working. I want you to evict them on the basis that they're violating the Controlled Substances Act. And the federal court judge came back and said, no, I'm not kicking them out. Because number one, there's no right, no personal, no private right under the Controlled Substances Act to pursue this kind of relief. You can't do that as a private citizen. And you haven't shown that there's an emergency to get these people out of here. They're current on rent, they're a good tenant. I'll see you at trial for your properties. So none of that worked. And again, the lease agreement is the way to go to prevent that. That situation could have been prevented very easily by having a clause that said, in the event of forfeiture, you're gone. And you agree to that, just basic. Now what ended up happening, it was a happy ending because of the Rohrabacher-Farr Amendment. Anybody know what that is? Yeah? Basically, federal government cannot expend funds to intervene with the state's medical marijuana program and implementation. Here in the Ninth Circuit, which includes California, the Ninth Circuit Court of Appeals has already held that that law has a lot of teeth, and what it really means is that the federal government cannot go around shutting down state law compliant actors. So what happened was that the DOJ dismissed its own case against Harborside, but that was about 5 or 6 years after the proceedings had begun. It just got renewed. Yeah, it just got renewed. Rohrabacher-Farr Amendment. Yeah, it's an appropriations rider bill, or language in that bill in the congressional budget. I think you were first.
Did the district court say they didn't have subject matter jurisdiction over eviction? Because I believe that's what I was told last week.
I'm not sure if they did or not. I remember the 2 main arguments because basically she didn't file for an eviction. She filed for an injunction, right? So she couldn't show emergency relief. Plus they basically said, you don't have a private right of action, which may have been the subject matter jurisdiction portion of it. Yeah, she didn't file for unlawful detainer in federal court.
So it's the idea that if you could have gotten, so you get the forfeiture notice that they're trying to seize the property, and then the idea is that if you can get the illegal tenants out, you could somehow prevent the feds from seizing that property?
This is a good question. Clients ask me.
That's why you want that clause to break the lease?
Yeah, clients ask me all the time, you know, because I have this clause, doesn't that mean they can't come and get me or my property? No. That's not what it means. You can't undo the deed. The reason to have it is kind of what you're getting at, really, is basically to abate the use to give yourself a superior negotiating position with the feds to back off. Because 9 times out of 10, what they really want is for you to kick out the tenant. Now that's got all kinds of ramifications. If the tenant's not otherwise in breach of the lease, you may have to buy them out to get rid of them. Normally the tenant is way too scared and will just bail. But if you get a Harborside that's got a war chest, they have a lot of money to fight the feds, this is something that it obviously seriously needs to be examined and should be examined in every lease.
When it comes to the self-policing you were talking about, do you expect that mostly to be people going to the state and complaining, or are you expecting a wave of like 17-200 litigation between legit operators and operators who are flouting the law?
No, I think it's going to be the first one, because I think most legitimate operators that are in the system paying their taxes, constantly being watched, will go to regulators to say, look, you need to crack down hard. And there will be enforcement officers, just like a liquor license. You'll have investigators, enforcement officers, and I'll tell you now, when you ask for a legal interpretation from these people or what to do, you're going to get 5 different answers, depending on the investigator, depending on the enforcement officer. This is notorious with liquor, and especially with administrative agencies. So you've got to be prepared, honestly, and I'm kind of on a tangent now, but to push back with what they tell you about the rules. Because I guarantee you the rules are going to be poorly written. They almost always are. SB 94 is poorly written. There are holes throughout it. There are lots of ambiguities, and we're going to discuss what those are, but don't hesitate to push back, because you can get an interpretation to your advantage without having a lobbyist, without having to go to court. In the back.
Can you seize real property administratively?
Yes, you can. Yeah, forfeiture can be administrative, civil, or criminal, and they like administrative because it's a hurried up due process procedure. Basically, you get one notice, one hearing, that's it. And you're not even the defendant, the property is the defendant. Anybody else from the law? Yes, sir.
Say you're a landlord in a residential situation similar to this, but commercial. It's residential where your tenants have a 215 card and they're growing X amount of plants. Could you get pulled in?
Yes.
Something like that?
Yeah, it doesn't matter if it's residential or commercial. Now, I will tell you, forfeiture can be a highly political animal. If the property is free and clear, that's a pretty delicious asset. Now, if it's got a bunch of mortgages on it or other liens and encumbrances, they may not be as interested. And they are political.
If you have a 10-unit apartment building and you have no idea that tenant number 7 is
See, now residential is better because that is the situation where you really can use the innocent owner defense. If you really didn't know, and you know, it helps people all the time where they rent these homes in like rural Kentucky and there's a meth lab, right? So that is a better situation. It's the commercial situation that is scarier, but in the residential situation, yes, the home could still get taken, but you may have the defense available to you. Yeah.
So would the civil asset forfeiture apply to essentially all ancillary businesses that do business with the MRB?
Yes. Yes. So the question was, would asset forfeiture basically apply to ancillary businesses? The answer is yes, because even an ancillary business is considered to be aiding, abetting, and conspiring to violate federal law. If you're an investor, if you're a fund, if you're providing grow lights, if you're providing housing, you're in that bucket. And then the question is, what is the enforcement risk? And to date, federal government really has not pursued ancillary businesses. Who has are regulators like the SEC, if you're publicly trading and defrauding investors, because a lot of ancillary businesses are trading in the pink sheets. A lot of them are run, frankly, by a ton of criminals. They're literally defrauding investors in violation of SEC rules. But yes, cannabis-adjacent businesses can be subject to forfeiture. There's no bones about it. The other issue for them also is money laundering when they take the check from the cannabis business for services. Yes, ma'am.
So with all things said, when do you think this fog is going to pass where, you know, there's more clarity, one, and secondly, I think so much rides on what the feds want to do with all this. Do you see that it's going to lean more towards the gates open and move down that path? And I know that's a broad question, but.
Oh, I like that question, and I think the second question is more practical because I think I can see where it's going, and anyone who's studied alcohol prohibition would probably agree the states are going to control this. Whether that results in something like the 21st Amendment, I'm not sure, but the feds have let it go way too far with these democratic experiments. So much so now, states don't even look to the feds outside of the Cole memo, they look at each other at how to regulate, and everyone is different. And every municipality therein is different. So I think it's gonna be, when we talk policy, over regulation, over government oversight, totally controlled by the states. The feds have frankly let it go too far. And if anybody has checked Twitter or any social media, you'll know the AP got a hold of some reportings from Jeff Sessions' Drug Task Force. They basically have said, let it be. Let it be. Yes, that's just happened in like the last couple of hours. Yeah, Washington State. I know, you finally bear some good news. Yeah, they basically have said don't touch it. And if anything, we need to research it more. Don't have a knee-jerk reaction, which obviously is not probably what he wanted. But he did write a scathing letter to Washington State basically saying, I don't think you're following the Cole memo, what are you gonna do about it? So we could see individual attention bestowed upon states if the feds think they're not towing the line.
So what's your source for that?
AP, Associated Press. I don't know the name of the specific reporter, but it's been floating around probably for the last couple of hours that the AP got a hold of this stuff because it wasn't supposed to be released publicly.
That's awesome. In what way did Sessions say that they were inclined to pull in Washington State?
I think product diversion was a big one. People basically taking stuff in and out of state. That was probably the biggest one. And then beyond that, I don't know. I didn't read that one as much. That was actually a separate story, if you can believe it. It wasn't tied to the task force. Yes?
So it seems like McCursa is written to try to limit vertical integration. within
So-
the state of California?
Let's talk about McCursa, because that's really why I'm here. I mean, all this federal stuff is super fun, but it's also entirely speculative. I do not know when the fog will clear. If I did, I would make so much more money, but I don't. Actually, now here's the deal. So MCRSA was the one that put the kibosh on vertical integration. Legislature really didn't want people to be able to do it all. They actually were making it very difficult. You could only have certain licensing combinations. You could only have certain amounts of certain licenses. All of that's gone. Under MCRSA, there are 20 different license types, from cultivation down to micro businesses. You can absolutely totally vertically integrate at this point. There are no limitations on the number of licenses you can hold, with the following exceptions. Type 3s, which are the mediums. This is not the biggest one, right? This is the medium, 10,001 to 22,000 square feet, indoor, mixed light, outdoor, basically up to an acre. You can only have so many of those, but the state has not said what the number is. Under the MCRSA regulations, it was 1. Many people think that they will do 1 again, okay? And then the type 5s, which these are your big Mac Daddy grows, bigger than 22,000 square feet, more than an acre, they are not even available for the first 5 years of the program. Also, labs, if anybody's interested in lab testing, because it will be mandatory, potentially very lucrative, they cannot have a financial interest, direct or indirectly, in any of the licensees at all, and that's pretty clear on the policy choice. They don't want collusion over test results or any incentive to cheat, okay?
So now a cultivator can be a distributor.
Yes, yes, and this is actually in my list. Let me go through my list of the highlights of MCRSA. Yes, you can be your own distributor at this point. This was a massive point of contention between lobbying groups and private interests. Under the MCRSA, you were obligated to use a separately owned third-party distributor. That scared a lot of people in the manufacturing and cultivation side of it, basically. They didn't want monopolies over distribution, which those interests were lining up. Now, you can be your own distributor. The only exception to that is the Type 5s. Type 5s, when they go live, they cannot be their own distributor. So that's going to be, I think, more liberal, but there are drawbacks in being your own distributor because of the logistics and the costs associated with that. Now, if you read the MCRSA rules, and this is just like alcohol, distributor actually has to take title to the product. They have to buy it, and then they have to repackage it, and then they have to get it to the retailer, but before they do that, they have to test it. So this is not like a transporter, right, just moving product around. This is a real live distributor with a network that basically for the entire state of California must guarantee and ensure quality assurance. So even though you can be your own distributor, there will be savvy people who say no way, because I'd rather negotiate with those guys than be one. Now, Nevada. Everybody knows, because this is the most recent tidbit of news, Nevada had massive shortages because they didn't license enough distributors off the bat. We have the same issue here. Distributors are the only ones who can move product between licensees so far. Another big difference between MCRSA and MCRSA, the transporter license is gone. The Type 10A producing license is gone. So distributors are going to be key, and if California is smart, they will not do like Nevada. They will license a ton of distributors so that the product can move between licensees. Now, another highlight in the MCRSA is that we will have temporary licensing, okay? This is big. Do you have a question?
So the transport license is gone. Has that been rolled into the distributor license?
No, not even. No, it's just gone. They just basically deleted it as a license type out of the MCRSA. And that was, you could exclusively just move product around, but you weren't a distributor. So as a transporter, you didn't ever take title to the product. You were just moving it, shifting it back and forth between licensees. But now that's been fully vested in the distributor as part of their job description. So it's just been phased out, really. Okay. Yeah, another big difference are the temporary licenses. So in the MCRSA, the old style was if you were operational, right, before January 2nd and you had local approval and you got your application in before July 2nd of next summer, you could keep operating. That's gone. They're not gonna mess with that anymore. What they're gonna do instead is that they're gonna start issuing temporary licenses probably beginning in October, so long as you have local approval beforehand, okay? Those are only good for 4 months. You still have to go get the state license after that, all right? So that is kind of a big change. The other big change is local approval. Who hates their city and their county? I know, I do, and my clients do, because they constantly change on this position about what they're going to allow, and lo and behold, the ones that rush to judgment to create ordinances now all have to go back to the drawing board because they don't line up with MCRSA. So again, there's gonna be another kind of swing through on the ordinance drafting that's gonna give everybody headaches. But of course, every city and county is doing it differently. Local approval under Mount Cursa has changed. It used to be that you had to have some kind of tangible permit or license to show the state as a prereq to getting your state license. Now, it's just local approval. That could be a letter of recommendation, or here in the city of LA, it could be that certificate of approval. That's a total nightmare if you know Measure M. If you don't worry, we're not gonna talk about it. So that's more relaxed. But now what's gonna happen is that when you file for your state license, the state's gonna notify your city or your county that you're coming into the borders. They're gonna ask the city or the county, are you in compliance with local law? Basically, if the county or the city says nothing, a legal presumption is created that you are actually in compliance and you can move forward with state licensing. They'll have 60 days to respond. And now if they come back and they say, look, you're not in compliance, there's a ban, we haven't regulated yet, automatically your license application is rejected, all right? So local approval is still key. It's a prereq to temporary licensing. It is still a prerequisite to state licensing, just in a different form. Yes?
What county right now in the state, in your opinion, is most business friendly?
County?
Yeah, like if you were gonna go somewhere and set up shop.
Oh man. I can't even name one. Cities are better. Cities are better because they're smaller. Actually, I'm gonna do a retraction here. I once wrote that LA County was probably one of the worst counties in Southern California. They're actually talking about regulating, and they want regulations within a year. That's super progressive, and obviously the largest county in state and hugely impactful. Yes?
Is it as simple as if you're located within city boundaries, you deal with those city laws? If you're located in the county line, you deal with those county laws?
Correct. So if you're in the incorporated portion of a city, you deal with the city. If you're in the out of bounds in the unincorporated county, your county, even if your zip code says LA. So you better double check, because there are huge differences between municipalities on this particular issue. So local approval is still key, you still have to have it. No, I do not have a good list of cities and counties. And I won't for a while because they continue to change. Yes, sir?
In terms of people using mixed lighting or no lighting at all, how are those people, has there been any consideration of those people integrating into municipalities because of the nature of it not being secure and being more open? Have they looked into regulating that at all, or is that not going to be completely delegated to
No.
county entities?
Yeah, the question was, have cities and counties really given any consideration to mixed light and outdoor cultivators, because the nature of the grow is a bit different when it comes to securitization and surveillance. The state is going to slap outdoor growers and mixed light growers around too. There'll be fencing requirements, there'll be lighting requirements. These will all come out in the regulations. We've seen it time and time again. Cities and counties have actually touched on this. If they're going to touch on cultivation at all, a lot of them have banned outdoor cultivation in Southern California. Way more common up in the Emerald Triangle, obviously, but beyond that, cities and counties are not fans of it. They're worried about the communal impact. They're worried about NIMBYs coming forward, potentially suing the city. They're worried about nuisance. So that one tends to get less love. Mixed light and indoor tend to carry the day in Southern California, which is going to be brutal for power resources. And just by way of example, a city like Palm Springs, they basically have said, yeah, come and cultivate, but we only want indoor, and you have to bring all the resources to the property. It's wildly expensive. Coachella is basically the same way. So double check your local laws, people. Some of them are super insidious, and if you cannot prove in some of these municipalities, Humboldt and Mendocino were part of this, and I think it's kind of giving a nod to people of the past, but they will have deadlines. You have to show that you've already been in operation. The city of LA is going to be the same way, so double check. And I think that's also a nod to the fact that another important point, Mount Cursa removed the residency requirement. There used to be a residency requirement under the AUMA of at least 2.5 years. Jerry Brown blew that away. He absolutely wants outsiders coming in. Foreign companies can also participate. Okay. Now, again, that can be curtailed by local law. The city of LA and its draft Measure M regulations, they will not allow foreign entities. So no Colorado businesses, no Washington businesses, no Oregon businesses, but on the whole, under state law, they can come in, they can participate. Yes?
What's the best way to prove this grandfathering?
So, depends on the city or the county, all right? But most of the time, at least what I've seen on the whole, on average, they want to see things like tax filings, receipts for costs, They want to see date stamped maps of your property, basically, when you were cultivating. Also date stamped photos, if you have them at all possible. And basically they'll take any piece of evidence, even a business card, to demonstrate that you were up and operating at X date.
Is this really going to be a big deal in the future on who gets the permits first?
I don't think so. There's only really been a select few that have done that, and I think it's where these heavy concentrations of collectives are Prop 215 operators, because that's kind of a nightmare for the county or the city to try to verify, and it takes a lot of manpower to go through those records. For example, City of Long Beach, none of that stuff. Their manufacturing and cultivation window is open right now. The big play there is real estate. Same thing with Port Hueneme, you've probably never heard of it. It's an obscure little place in Ventura County. They're going to regulate everybody with the exception of commercial growers. They don't have any premiums for past operations. So it really just depends on the city or the county. And yes, some of them are very, very expensive. Don't go to Costa Mesa if you don't want to spend more than $50,000 on a conditional use permit. Obviously others like Needles, Adelanto, Desert Hot Springs, these are very turnkey, easy applications. In disenfranchised communities on the whole, they want the economy, so they make it really cheap to get in and to operate. So it really just depends on where you're gonna go. In Southern California, I don't do anything really north of Central Valley, so that's kind of my focus. You and then you.
Are you still advising companies just setting up this business to form as a mutual benefit corporation?
Oh, you knew this was going to happen.
And those who are you advising them to convert to a for-profit, and if so, as of which date?
Okay, that's a very good question, very technical corporate question, and I'm gonna give my most candid response. At this point, Prop 215 probably has about a year left on its legs. The legislation is clear that up to a year after the first licenses begin to issue, Prop 215 is going to be repealed. Knowing that, and knowing that temporary licenses are going to issue in the fall, depending on what the locality says. If the locality says that the applicant for a conditional use permit or the license can be a for-profit entity, I am an advocate of going for-profit. And to the naysayers who think it's not a done deal, read Malcursa, read the MCRSA regulations that were repealed. The applicants can be for-profit. And it would be insane to enter a regulated market as a nonprofit. It is very, very difficult to sustain because a nonprofit, they can't take investors, they can only take on loans and debt. They can't recruit good talent away because the salaries can only be so high relative to your private market competitor. There are big reporting problems with the IRS. So, and you're not going to get that 501c3 status anyway. So I recommend going for profit as long as the municipality allows it. Now there are some crazy folks who think a merger is a good idea. I've never really understood why this is the case of the nonprofit mutual benefit corporation. I can understand it if you have some goodwill or intellectual property that you've been able to secure somehow, either through asserting common law rights or maybe you got a state law registration somehow in the past. But I don't really recognize the benefit of merger. And again, if they have a local permit already in the nonprofit, merger might make sense, but we also have a problem. Most of these permits are not transferable between entities. So if the surviving entity is the for-profit, your permit is probably extinguished. Also, just so you guys know, the licenses from the state, they are not going to be transferable. You will not be able to sell them like taxi cab medallions. It's going to be a lot of B2B M&A transactions at the end of the day, and you guys are going to see it. There'll be an entire market for people who flip their licenses. They won't do a day of business, and they will sell their built-out shops and facilities. That was one of the first things we did in Washington, and it kind of blew my mind, the prices people were willing to pay. But again, that really depends on the exclusivity of your local jurisdiction. Some of these cities and counties, you will note, they're only allowing so many operators in. So even though the state has no cap, the locals are going to cut that down at the knees, depending on the jurisdiction.
Sorry, did you just say, you said the licenses are not transferable? Did you use the word permits as, you're saying license and permits, you're using them interchangeably?
No, they are absolutely two different things. On the local level, predominantly it's a permitting system, and a permit runs with the land. So the permit is not transferable between the businesses. But if a new tenant comes in, they can benefit from it. If someone buys the business, they can benefit from it. The state licenses also will not be transferable like personal property. They will be a privilege basically assigned to the business, and the business that holds it can be bought and sold, which is kind of a pain in the ass on due diligence and M&A because you have to buy all the liabilities that go along with that company.
What is a good resource? I mean, I know that you're kind of stressing this whole checking with local municipalities and all that stuff. what is a good resource in order to, because I mean, it's been very difficult for myself at a personal level to actually acquire that knowledge from local people. It's been very difficult. Is there a resource that you can recommend where it's easily summed up and we can find where, who stands where, and who stands
Yes,
what?
there is a resource, but it's not free, and it's not even something that I would take at face value. You still have to dig beyond that because of the way local government operates. They can do things very quickly, or they can take a long time and be very transparent. Again, really depends on the city or the county, but there is a service. It's called Canaregs.
Yeah, Canaregs.
Canaregs. Cannaregs. And again, I don't take it at face value. It's my starting point. I have a lot of clients. They don't have the bandwidth. They don't have the time. They have other jobs. They just don't want to sit there looking at municipal codes all day and changes and amendments and urgency ordinances, so they delegate it to us. So we have Canaregs, and we have a California subscription, and you know it's worth it because there are 482 cities and 58 counties. It is a beast to keep track of that. But again, even then, there can be things that are not updated on Canaregs. You must double check with the municipality, whether that's a call, an email, you know, relentless doorbell ringing, I don't care. You have to get straight because that will make all the difference. You know, the property you're gonna go to, the permitting that you have to get, the level of compliance, it's huge.
Canaregs is what it says on the label. It's the regulations, they're redlined to show you changes. California only, last I checked, was a little under $500 a month. Mm-hmm. So you need to be able to read and interpret legislation, and you have to remember that the legislation, the regulations are not all the law. So we were talking about Harborside a little while ago. I'll say it so that our presenter doesn't have to call a lawyer and ask them what the law is. Don't try and decide yourself if you're playing with large amounts of money.
Yeah, and you know, on the lawyer thing, get a local. Get someone who's there all the time. You know, someone in Los Angeles isn't going to know what's happening in San Francisco. I mean, they might, but it's highly unlikely because it's just so fluid. So get a local. Any other questions?
Just to jump back to asset forfeiture real quick, how many cases have you actually seen in California where somebody's had lost land?
For state legal business.
So, and remember guys, it's not, medical marijuana was not legal here in California. It was an affirmative defense. That's it, right? So I would say in the past 5 years, maybe 4 or 5.
Out of that offensive operators.
Yeah, but I mean, maybe. We don't know how many there actually really are. It's not been something that I've tracked closely outside of the state legal setting. So I couldn't tell you. It's probably way more than that, to be honest with you. Yes, someone over here had a question.
So an out-of-state business, you know, strategically easier to acquire an in-state business that had operations prior to versus greenfielding and acquiring a new license?
I wouldn't say it's easier. Obviously depends on the terms, which who knows what those would be. A lot of out-of-state companies, what they do is because they don't want to come here, first of all, they don't want to pay all the taxes, and they don't want to do the logistical nightmare of lobbying a city, getting an ordinance passed, pursuing a state license. They will do intellectual property licensing. They will license in their trademarks, their brand names, their methodologies. They'll take a royalty if that's allowed by state law, and that's good enough for them. As long as their logo is on a brand and on a shelf somewhere. A lot of them operate that way because it is very difficult to come in and actually operate. Plus, that relationship doesn't put you in bed with an operator you don't know. And a lot of California operators have significant corporate tax and financing issues, especially here in the city of LA. Okay, last question. Sorry, guys. In the back.
So I give a lot of credit to the states that were the up-and-comers, you know, busted into this. Are there any states that you see that are doing a really good job at, you know, transforming this marketplace? I mean, or, you know, kind of leading the path?
You're probably not going to believe it, but my personal favorite actually is Oregon.
Really?
I really like Oregon because I'm very pro-business. I think, you know, the invisible hand is real, and the people who are doing it right, the people that care, they will survive, and those are the people that I want at the helm, kind of driving industry. They're not the people I want making the policy decisions, but they tend to hoist up the people who care about compliance, who have good product, who are not going to poison people just to make a dollar. And by the way, products liability in cannabis is 100% real. And that's going to round out here, especially in the state of California. But I like Oregon because it's really business friendly. The policy decisions make sense. Somehow they have towed the fine line of not creating that culture of folks who are so reliant on cannabis, yet they are very pro-business. And I do not know how they did it. And maybe it's because they're smaller. Half of California's problem is going to be it's just so big. And to regulate it effectively is just going to take years, probably. And with that, I said very little about the Malcursa. I really apologize, but I'm glad I got to answer some of your questions. And with that, Brad, take it away.